Hello, everyone. I am delighted to welcome you to today's webinar um, hosted by AI Chamber. My name is Agnieszka Gosztyła, and I look after growth and partnerships here. Today, we'll be diving into a timely and important topic, the AI Act. We are honored to have with us Professor Mihael Mudrić. Michael, are you with us? Mihael?
I'm here. Hi, good
Yes.
morning.
Hello, welcome. Mihael is associate professor of law at the University of Zagreb, and who will walk us through the practical implication of the regulations. Before we get into the presentation, let me briefly share who we are at AI Chamber, our mission, and our values. The AI Chamber was founded to create a collaborative space where dialogue, expertise, and advocacy shape the future of AI in Poland and across Europe. Our mission is to empower our members, from startups and SMEs to public institutions and enterprises, by providing representations, a strong voice in the national and European consultancy on AI policy, knowledge, executive insight, legal updates, and case studies that make the AI landscape easier to navigate, connections and network of innovators, leaders, who's meeting at roundtables, working groups, and business events. And of course, educations, webinars like this, workshops, trainings, and programs tailored to real world challenges. If you would like to join the chamber, become our partner, or simply stay in the loop, you are welcome to connect me directly. I will share my email and LinkedIn profile at the chat box. A quick few notes before we start. Today's webinar is being recorded. The session will last about 45 minutes, followed by 10-15 minutes for Q&As. You are welcome to ask questions at the time, posting them in the chat. We'll collect them, and Michal will address them during the Q&A session at the end. And now it's my great pleasure to hand the floor to Michal, who will guide us through today's topic, AI compliance, build your self-evaluation strategy. Welcome, the floor is yours.
Thank you, Agnieszka. Pleasure to be with you. Good morning to everyone. I have no information on how many of you are out there listening, but I'm looking forward to reading your comments or hopefully questions or any kind of an experience you'd like to share on this issue, on this topic. I don't know whether you can see my presentation. Is it available? Is it running, or can you give me some hints there, please?
Yes, but maybe before we dive in, maybe we can do a short Mentimeter
Yeah.
a quiz for our participants. One moment. Okay, so here you can see the QR code that you can scan or use address menti.com. Please put the code mentioned on the screen, and we will dive to the short quiz. Okay, I see that we have some people with us. Let's go to the first question. How familiar are you with the European AI Act? We have the scale over here, so you can mark that you are not familiar at all or you are very familiar. So we are encouraging you to vote here. Okay, great. We see that we have different opinion here. Great. Let's move to the second question. Which risk category do you think most of your organization's AI systems fall into? We see one limited risk. Let's wait for the more responses. Okay, I only have one answer. Let's move further. Last question. In one word, what comes to your mind when you hear AI compliance? Feel free to use different words, just what's in your mind. Rules. Mihail, you have any thoughts about this?
Maybe people are just interested to first hear what I have to say on the subject matter. We'll see. We'll see.
Okay, actually, it's interesting that we can ask the same question at the end of the webinar.
Yep.
Okay, great. Thank you very much. So let's move further. The floor is yours.
Thank you. Now, about that presentation, is it available or should I share my screen again? Okay, it seems it is working. So again, good morning, everyone. I've been working on the issue of AI compliance in terms of the European AI Act for quite some time now. I've done some work with the private sector. I'm doing a lot of work with the public sector as well. There are AI literacy programs that I'm conducting with several state institutions in terms of preparing the civil servants and in general people in the local government or nation government in terms of what it is that they are supposed to understand and know when it comes to the not just the compliance with the AI Act, but also some basic terms connected to the technology and something we refer to as the artificial intelligence. The objective of this, as Agnieszka has already stated, is to give you some perspective on what this compliance really means in practice and what it is that you are supposed to do within the next roughly 1 year. We expect that most of the rules within the AI Act that concern the high-risk systems will come into force next summer. And so the timing is crucial to start preparing for this and become aware of what this means for your business. I assume most of the colleagues here who are with us this morning are coming from private enterprises, possibly startups in connection to the AI software that they're producing. So hopefully this will be of interest and give you some idea and rough perspective on what it is that is expected from you, and more importantly, why is this something that the European Commission and all the other bodies within the EU feel that the businesses and public bodies need to do when it comes to the use of software, artificial intelligence in everyday life. I'll try to go quickly to some basic points concerning what is referred to as the AI compliance, understanding some of the key points, identifying what it means to have a AI program software system that poses certain kind of risk to your users or to third parties or society at large, to understand what is your role, what is your individual responsibility as an organization in terms of trying to be compliant with the AI Act. And then in this, how do we approach this compliance responsibility in a practical manner, what it is that we need to do? And is there something that can help us and guide us on our way, something referring to the international standards that I will mention at the very end? I'll try to be as quick as possible. I'll try to leave as much room for the questions or comments on your side. I have a second monitor here with me, and I'll be looking at the chat. So if there are any questions, type them immediately or comments, and I'll try to refer to them not only at the end, but also throughout the presentation. Now, when it comes to the compliance, and many of you may have remembered the GDPR compliance and all the fuss that was connected to this. Yes, you can look at the compliance as something that you have to fulfill. Otherwise, you might potentially be sanctioned and you might pay some money. Of course, this is something that many companies will be looking at as a risk they're not willing to take. However, when I talk about compliance, I always feel that compliance is less about avoiding sanctions and more about enhancing your own business, your own operational procedures, methods, protocols and mechanisms that you insert into your business to be able to communicate better, to resolve issues better, to share information among your employees, and literally to be able to function better in an environment which feels that AI might potentially be hazardous as well as efficient and a tool that will enhance your efficiency. So in other words, I would use the compliance to educate your own employees, and give them the knowledge and understanding of the issues that will help them not only to understand the basic issues, why we have the AI Act in the first place, but also how to use certain programs, certain software diligently, and be able to understand what the risks are that are associated with such work. So in terms of the foundations of AI literacy, what we are primarily interested in when we, for example, look at the definition of the artificial intelligence within the AI Act is those systems, those AI tools or AI advanced generative tools that will provide us with some predictions and even some decisions. And the question is, main question we have to ask ourselves, are we capable of relying on such systems? Do we trust that they will make the correct prediction that we will follow, likely follow, or whether they will autonomously achieve a certain level of decision making that can be followed by humans and that can influence humans, us as the people who are using the systems, or us who are feeling the outcomes of these systems being used? And that is the main issue. To what extent are we ready today to utilize algorithms, different kinds of software and programs in our everyday work, everyday things that we do, to the extent that we are able to say, yes, this is trustworthy, this is safe, this is something we control, we understand, and we are able to react in case things go very or wrong. There are four risk tiers. The AI Act as well as the GDPR are risk-based. So basically, they're saying for most of the software that is being used today, very little, if no, requirements will be needed. This is not something that the AI Act is dealing with. However, in that limited number of cases where AI systems pose a moderate or a significant risk to the society at large, meaning that if something goes wrong, a lot of people could feel negative outcomes from the use of such systems. One has to make sure that they, in their business procedures, fulfill a certain number of criteria related to the responsible and safe use of these systems. Just to give you an example, the Danish, I think, government recently made a survey of all the algorithms, all the software that is used in public sector, and they've tried to classify them in accordance with the AI Act, and they only, I think, came up with a percentage of 12% being classified into the high risk. And usually this concerns social services, critical infrastructure, law enforcement, and usually such high-level systems that deal with a lot of data coming out from citizens and making recommendations, predictions related to the benefit of the citizens in one way or another. We have had a number of examples in comparative perspective from Europe, from United States, Australia, if you like, where organizations such as social services have utilized different kinds of software. Turned out the software wasn't really calculating things well, and a lot of people lost the opportunity, for example, to see their children, to receive some benefits in terms of financial additions to, or add-ons to in terms of child support, et cetera, et cetera. And this turned out to be a very big deal in terms of how we approach the fundamental values of our society and what are these values that we wish to protect. The main problem was that for a number of years, these organizations were not able to detect the algorithm isn't working well. And a lot of people have because of this, had a number of negative outcomes on their own behalf in terms of their family life and benefit. So this is the sort of values we're talking about. Again, in most cases, the risk associated with the use of AI systems or AI tools will be of a limited nature. I'm just giving you some examples here. If you have a simple chatbot that is able to communicate very basic information to the users, this information also being available on a public open website, open web, it's unlikely that this might potentially cause any significant harm due to the fact that this information is available through other means as well. If, however, you're utilizing chatbots to offer services, to sell tickets, to provide certain opinions, this could result in a more significant level of harm in cases these chatbots virtual assistants are performing as they're supposed to perform. So this level of risk means, translated into everyday jargon, means that you, as those who are either developing a certain piece of software or deploying a certain piece of software, need to think, what is the level of risk associated with a program that you're developing or program that you're using? Now, how do you? Is there any way that the Commission, or rather the European Union, has asserted how this evaluation should be made? did they make it more easier to classify your own software, your own systems? The answer is yes. And the method that the commission has offered is twofold. First of all, in Annex 1, you will find a list of European legislation related to certain items, as you can see here. For example, regulations that deal with regulating machinery, toy safety, lifts, different kinds of specialized equipment, et cetera, et cetera. All these systems and all these services are considered to be either dangerous or so much important that they required a specialized approach by means of regulation, requiring a lot of technical standards and conditions to be applied when these products or services are placed on the market. And this is recognized by the AI Act as well, by means of asserting that the software that is utilized in connection to these services and these goods is automatically considered to be high risk. So if you're in these sort of markets, if you're producing very specialized kinds of products that are regulated by the European legislation that is posed, that is inserted into Annex 1, it's very likely that you will fall onto the high risk area. The second, I said twofold, the second criteria or second helpful aid coming from the Commission is Annex 3, where you will find a specific list of use cases of AI systems. So it's not a closed list. By no means. It's not meant to be a strict list. You could, for example, be providing a service to a critical infrastructure. For example, your client could be an energy utilities company, and you might be working with them developing various kinds of softwares for them. As you can see, the first item on this list is critical infrastructure, but it does not necessarily mean that the program that you're developing for the energy company is high risk. You need to assess to what extent is this program used for their own needs and the services that they provide. And it could be that if it's connected to the way that critical infrastructure functions, for example, balancing of the system, it's very likely that your program will fall into the high risk category. So you need to carefully consider not only what it is that you use, what it is that you develop, but how will this software be used by your clients, by the people who have connection to whatever it is that you offer. And this might provide you with a critical answer on whether you in one way or another is connected to the high risk use of such a system. I will come back to the point of providers and developers in a bit. But this is just to give you an idea. This can be very useful. Point number 4, access to essential services. Here I provide a example of credit scoring, which is quite interesting because to that end, we already have judgments coming from the Court of Justice in Luxembourg, providing very specific rules when it comes to the way that the information is being shared, the information is being collected, analyzed, and what the outcome of this analysis is for the society at large, for the citizens at large. And there's a number of cases concerning credit scoring, et cetera, et cetera. I'm not going to go through this now, but just to give you some idea that there is some case practice coming out already. Then step 2, even though you have a software that could potentially be a high risk, it does not necessarily mean that ultimately it will fall into the high risk category. What you will need to do is you will need to ask a number of additional questions, such as a significance of this risk. Is this a risk that can be tolerated as a normal risk that one faces every day when one uses a piece of software for any purpose, or is it a specific risk that relates to the health, safety, fundamental rights as available in the Charter? Not going to go through this now, but the point is, I would definitely recommend that for this specific part of analysis, if you have no in-house lawyers, you get somebody who will consult you and help you with this, because the analysis and evaluation to this account can be very specific, and one has to carefully observe the fundamental values that are promulgated by the European Union and try to assess which of these actually refer to what you do in practice, what kind of business you have, and what kind of outcome the software that you produce or use can produce on the citizens at large. What do you have to do if you are high risk? Let's say you have a number of companies that you're quite certain will use your software to provide certain services that are considered to be of high risk. And it's quite likely for you that you will have to apply or comply with the AI Act because you are producing software within the high risk AI systems category, what it is that you need to do. So what is this compliance? What awaits you in the, let's say, next 10, 11 months? First of all, it's very likely if you're a bigger company with a certain history of producing similar software that you already done a lot of work in terms of the compliance. The first item on this list of compliance checklist is the risk management system. However, if you've already established a risk management system within your company, if you are, for example, certified in some of the ISO related standards, it's quite likely that you already have a risk management system in place and that you will very likely be able to accommodate the need for AI compliance within this system. So, in other words, you will need to look at your protocols and your mechanisms. What happens? How do you approach risk management? How do you approach dissemination of information in case the risk occurs, et cetera, and whether it's possible to integrate the risk related to the AI system into the existing rules and protocols that you have in place. This could be very useful because for you, it will definitely shorten the process and it might even enhance the procedures that you already have in place. In my own experience, having worked with several companies in Europe and a few in the United States as well, uh, the analysis being done by them, especially those that are state-owned, turned out to point to the fact that they assess that they require a completely new risk management system when it comes to the AI systems, simply because of the complexity that the AI system brings into the whole scheme of risk management and the necessity to incorporate the work of all the sectors, sections, departments within their organization into a new um, system of communication primarily and understanding what the risks are in the first place. And this not only relates to the cyber defense or encryption defense, but to the basic understanding of what certain tools offer, how to use them diligently, and how to understand that they might not be perfect or they might not relate to something as simple as the calculus, meaning that the outcome coming from the latest generation of generative AI might not necessarily be useful to the extent that you can trust it completely. It really depends on what it is that you use. In any case, as I've said, a lot of these companies that I worked with have thought through it carefully and decided to make a whole new risk management system related to the AI. And to that end, they use the ISO 42001. I'll come back to this at the very end. Second of all, data governance. If you're a developer of an AI specialized AI generative tool, and AI bought something in the words of ChatGPT, but it was specialized purpose. A very important thing that you need to consider is data governance, and especially data quality. What data are you using to conduct data training through machine learning or perhaps even deep learning, depending on who you are and what it is that you do, and whether the data that you utilize for this data training corresponds to the needs of the clients. If you have produced a highly valuable AI tool for a Polish client concerning transport, concerning medical facilities, concerning public sector ministry or something, one has to ask whether this specific tool, trained as it is, will be of same use in, let's say, Croatia or France or Germany. Why? Because the circumstances of where the program is being deployed might differ, and the data needed to be taken into account might differ as well. There's great many examples of this data quality issue being felt in the insurance sectors. A lot of the insurance companies today are using algorithms to automatically calculate policies. The way they do this, they produce very advanced algorithms that are capable of assessing the, let's say, for example, the duration of a policy insurance for medical costs. And then it turns out in practice, you have a number of cases happening today before the US courts where people have been thrown out of hospitals because their insurance coverage has ended after 2 weeks, whereas they were required to stay in hospital for 2 or 3 months. This was automatically generated by this policy. This coverage has been automatically generated by the algorithm based on the data that was erroneous because it showed that people don't require more than 2 weeks for a specific kind of illness. Simply because the data used for training did not relate to some other issues that were required. But nobody saw this before it was too late and people suffered. So it's very important to bear in mind who your clients are and whether you're capable of achieving the adequate level of data that is necessary to properly train your algorithm. And this is one of the things that are now being looked by the AI Act Are you diligent to this matter? If not, then this can directly lead to responsibility and liability. This is why I'm placing this here. Technical documentation, to a certain extent, you have to make available certain information on your algorithm. You don't, of course, have to disclose anything that is IP related, but one that is using or one on whom such algorithm is being used need to have basic understanding of how this functions, how this works. This is all being now thoroughly analyzed by Sentinel and the European standardization framework organizations. Hopefully, very soon we'll get the first standards out. They should have been out in August, but the chairman of Sentinel explained that it's a very complex issue and they require more time, and I completely understand this. Finally, the record keeping. I would assume that all of you have such a thing in place already for whatever it is that you do. If not, this is something you have to implement. It is not only important for you as your own organization or the client's organization, but it's a key to help you improve your algorithm once your client starts coming back with feedback, possible glitches, et cetera, et cetera. Without the proper record keeping system, the retraining of data and retraining of the algorithm will become very difficult. And then finally, transparency, some basics on the user information, and robustness, the last point, accuracy. To what extent are you able to detect issues or withstand potential attacks from the third parties? The point that is very problematic and very questionable is the human oversight. This relates not only to the possibility of your clients or you yourself to be able to access the system, the decision making within the system, and try to influence this or stop the system from working if anomalies are being detected. But also this refers to the capacity of either you or your client as the deployer to be able to recognize that there is something faulty or glitchy happening with the system in time before any damages start or any serious damage starts to occur. This really depends on the kind of system that you produce, the complexity, the inflow of the amount of the data that is coming in, that is being analyzed at every single second by the system. And this turned out to be very problematic in practice. This is where most of the case law comes out, people simply not being aware of the fact that the system doesn't really work the way it works. So how do you start? What do you do? How do you approach this compliance self-evaluation procedure? It, First of all, it depends on what your role is. Now, if you are those of you who are here with us today, if you're on the startup side that is writing code, it's very likely that you will be on the developer side. And that means that you are the one who bears the primary compliance burden. So you need to do all of these things that I've previously mentioned. You need to prepare everything that your clients will be able to make use of. The best approach is to connect to the client as you develop and then communicate with the client. I've done some of the work in that field as well, where basically I was asked to advise on how a client, what kind of questions should the client pose to the developer to make sure that they are compliant once the program reaches them and they start using it. So basically what you need to do, you need to establish a very strong commitment in the two-way communication between the developer and provider, not just in the phase of development, but also phase of deployment, especially if you remain connected to the client as a backend operator, and especially if we talk about advanced generative AI tools that need to be retrained continuously to achieve better results and better efficiency. So to that end, be certain to understand what your market is, who your potential clients are, who their clients are, and how it affects third parties as well. Because all of these things need to be inserted into your code, if you like, by design. Some of you may have heard about the title or the term privacy by design. Same thing applies here. You need to think in advance what it is that you as the developer are required to ensure exists in the first place. And how do you achieve this? By making sure that it's a part of the system in the first place. It's easier and better to do it as you develop than later on once the product is out there in the market. If you're on the user side, deployer side, you need to be aware of the fact that you deploy this, you haven't developed the system, but you deploy it on your own authority, or you distribute it on your own authority. So you need to understand that even though the primary compliance obligation relies or is placed on the developer, you assume responsibility for the effects that are felt in the environment once the system is in place and starts generating different kinds of outcome. Second of all, you're a key player in terms of monitoring, supervising the way the system works and detecting issues that occur in practice. Was it a bug? Is it a glitch? Or is it a feedback you received from your own client or a third party saying, I think that the system doesn't really work well? It's on you to evaluate to what extent you need to involve the developer, almost perhaps immediately, perhaps at a later stage, but in any case, to try to detect what it is that is wrong and how to amend this. Very important thing, the last sentence here, deployers who are public bodies but also who are considered high risk must conduct a fundamental rights impact assessment. This is what I referred to earlier when talking about fundamental values. There's different kinds of methodologies how to do this. But in any case, the point is you on the user side, on the deployer side, you need to understand and know why it is that you need such an algorithm, such a program. How do you use it and whom it affects, and to what extent it affects people at large, your other clients and citizens that require your services. How long will the program be used, and how long the outcomes of this program will be felt in the society at large. So you need to make an assessment, or rather an action plan, on how it is that you intend to mitigate all the negative outcomes that might occur, or the potential risks that might come to be, and what kind of a risk management system you have in place to be able to prevent serious damage or any damage from occurring in the first place. Again, this is a very complex thing, and I would, to this end, recommend consulting experts in the field to be able to help you properly, especially if you're on the IT side. You might lack certain knowledge in this respect, which is more legal, less IT. In practice, from what I've experienced myself as well, as it becomes very blurry at one point, where you have a continuous engagement from both sides on one end and the other, and it's at one point very difficult to assess to what extent the deployer eventually, or even from the outstart, becomes a developer as well, due to their input of information, data, directions of how the algorithm, the code is to be written. So it can become very complex. The best way to manage this is to very precise contractual terms. This is my definite recommendation to this end. Be very careful. You don't want to think about issues after they occur. You want to think about them before. Practical compliance pathways. Some of you, depending on how large your organization is, some of you might be able to do all of this on your own. Some of you will require outside help. Some of you will be able to follow the basic guidelines as set by, for example, international standards. And some of you might require some auditors to come in and help you with preparing for a audit in, let's say, ISO standard. In any case, you can start on your own by doing this. Make an inventory. What software do you use? What it is that you use? Make a list. And then after you made a list, try to think of the risks associated with each individual program that you use. When I teach AI literacy to ministries and governmental agencies, I always tell the public servants who come to these lectures, ask yourself, what are the programs that you use? Is it just an email office packet, or are you using specialized programs, for example, for public procurement? What happens if the program it fails, if it stops working, it's not accessible, or simply there is a glitch that disables people, for example, from applying for public procurement? Is there an alternative you can use? Is there do you even know whom you should contact? What it is that you need to do in such a scenario? How do you behave? And is there a way to mitigate and prevent from ultimately the damage from occurring, or making sure that you're able to perform service in another way? So make this inventory on your own, classify them, try to assess whether these programs that you use might potentially be risky, programs that you develop might potentially be risky for your clients or other people. Then do the gap analysis to the best extent that you can. Do you have a quality measurement system within your organization, or risk management system? Do you already have something called data governance? Do you have people within your organization who have certain responsibilities when it comes to any of these things? Do you have a filing system in place that contains technical documentation that you can show to other people when necessary, that it's all there, ready? Are you prepared for events that you would prefer not to have occurred but have occurred? what do you do? And then finally, after you've done this analysis and discovered perhaps that you lack certain things, make an action plan. Again, you have very little time. The last thing you want to do is starting on the 2nd or 3rd of August next year is to have somebody from the supervision authority in your own nation coming, knocking on your door and asking for all these documents, and you have none to show them. So be ready by then. For some of you, this might take more time, for some of you less, but ultimately, if nothing else, it will help to enhance the capacity of your own employees in terms of understanding what it is that we're talking about here and why all these things are important, what can happen in practice, and what you need to be ready for just in case things go not as planned. So make sure you have some sort of a plan as well. Ask somebody to help you. Have nobody, if you have no one within your organization that is capable of doing this. Finally, on the very last point, the member states are now expected to come up with so-called sandboxes, meaning that this is a closed regulatory framework regime that allows you to test your systems without necessarily being compliant with the AI Act, without developing all of these things that I've talked about. This serves to protect you from any liability, responsibility. It's a closed environment. We'll see how this will be regulated in practice, but in any case, this should enable you to test out your systems without fear of being sued in a court because somebody sustained some sort of a damage. I cannot talk about this more because we lack practical inputs on the member state side as well as the commission. And then finally, and I'll try to close with this so we have more time for hopefully some questions. I'm looking at the chat, but I'm not seeing any messages. We'll see. Hopefully there will come some questions from your side. How do you do this? Is there a guideline that you can follow? Is there something you can do to this end? Well, yes. There's a number of standards that are coming out, and they will help you if you just look at them, if you read them, if you try to do self-compliance. It will serve to help you with something that is called presumption of conformity. A lot of the clients that I've worked with, I've done a lot of work in privacy policy, and many of them initially told me our legal department has told us that we are GDPR compliant. And then my immediate answer to this is there is no such a thing as GDPR compliance. You're just simply presuming you're compliant, but we need to test this out in practice. It's not the same thing when it comes to the AI Act, but the philosophy behind this is very similar. You need to try to assess whether you yourself are able to come up with sufficient number of protocols and mechanisms, put them in your everyday business operations, operational management to be able to say, yes, we are ready when it comes to the negative outcomes that might occur when we use AI systems. This is the basics when it comes behind this. And what can help you? Well, a number of different kinds of guidelines, standards are already out there. When it comes to the international standardization organization, there's already 42,001, 5, and 6. That it's, as I've written here, fantastic first step just to go through this document, see where you are, and see whether you can even understand what is meant by certain points here. The best way forward is to get an audit for this ISO standards, because then this is, as well as the NIST, this is the American counterpart, and they've come up with a standard that is very familiar or similar to the ISO 42001. Any of these two will help you immensely when it comes to the self-compliance. And of course, if you decide to do the audit for this, even better, because then you're telling the world we are ready and we've done the best that can be done right now in the world. We'll see what CEN, the European standardization organizations, come up with. I expect that this will be to a certain extent similar to the work already done by US and the ISO. There's a number of others that are quite relevant. I'm noting only one, 22,894, which will help you to understand. If you're not able to understand in practice what this AI-related risk management means, perhaps this standard will be able to help you with this. I'm already seeing some points in the chat. I'll come back to this in a second. So to conclude, risk-based approach and understand your role. These are the two, in my mind, most important things. Try to see whether the thing that you're deploying, the thing that you're developing could potentially be risky for your clients or for the users of this system. I've done a lot of work with the Croatian Ministry of Justice, and I've done a lot of, we have a summer school, for example, for high-ranking judges and public prosecutors, and we discuss a lot of the use of AI system in the judiciary. And there is a huge amount of concern there. To what extent are we ready to allow AI systems to take over certain roles in the judiciary. But then again, one has to be very careful when considering what it is that we want AI tools to do. Are we simply employing a virtual assistant on a website of a court that allows people to get some basic information when the court is open, how do we file a claim, et cetera, et cetera? Maybe some basic information already available on other websites is something that is not considered as a high risk, but maybe minimal or perhaps even limited risk, but likely minimal. Or are we using an AI tool that will help judges to scrutinize a plethora of documentation coming in, maybe even summarize some of it, or maybe even, as is the case in certain jurisdictions, prepare a draft of a decision, or at least a part of the decision. So these are quite different things, and the potential outcome is quite different when it comes to the negative outcomes. And one needs to carefully assess what it is that we want to achieve and what are the best means of achieving this. So the higher the risk of something going wrong, the likelihood is better that your AI system will fall into the high risk category. And if this is the case, and especially if this is the case, understand your role, what it is that is required from you, even if you're on the deployer side, if you are in the distributor side. There's many other roles or stakeholders that are nominated by the AI Act. I've only added a few here, the two main ones. But it could be that you're involved into some of the compliance requirements, even though you haven't really developed the system yourself. So you need to be able to understand what it is that you do and how do you do this. I'll stop with this, and I'm gonna immediately go into your questions. There is no way to be, somebody said there is no way to be 100% GDPR compliant. In my experience, very good point. In my experience, a lot of the companies that I worked with, when I've asked them to show me their privacy policy or this so-called compliance, GDPR compliance checklist, what I would usually get is either a piece of paper with some dots saying, yes, we are compliant, we are taking care, we make sure that we get compliance with people whose data we use, we make sure that we report everything, et cetera, et cetera. But when you look at it carefully, you realize that somebody just simply copy pasted some norms of the GDPR into this piece of paper, or a implementation act wherever they are, in whichever member state they are. Usually member states have a special law for the implementation of GDPR, which stipulates some additional things, for example, video surveillance, and then they will simply copy paste the norms of the law. But that's not really compliance policy. That's not really a privacy policy. Privacy policy is meant to explain how you actually analyze the data, and more importantly, how do you actually protect the data? Who within your organization is in charge of what? You can even nominate people, whether these people are trained, whether these people have NDAs in place, et cetera, et cetera. So if you look at the practice of the national agencies for the protection of personal data, the decisions they reach, and the penalties they give, it's usually related to the fact that all those people who are organizations are being penalized, sanctioned, have had such compliance documents in place, but in reality, they don't really make sure that this is being done in the real world. So that in the real world, in the way that they do their business, they haven't ensured that this is respected and that this is really being supervised in practice, whether this protection of data is being done. So I think we'll likely face similar issues here when it comes to AI compliance. My projection is that most of the companies will wait until the last moment, and then they will start calling people like me, asking for some sort of compliance measure, document, whatever it is that consultants can come up with within a week, to be able to show to somebody, yes, we're compliant, we're done. But that misses the purpose. The purpose of this compliance is not to be able to produce a piece of paper and say, yeah, we are ready, but to make sure that your employees within your organization understand what the core issues are, what the fear is, where the fear lies, why are people at large concerned about the use of AI, predominantly because there is lack of understanding in the general population what it is that these programs do as opposed to what they do not do. So you need to be ready for this. You need to be ready for a lot of pressure in this sense. And in order to alleviate this pressure, use this opportunity, this current year we're in right now, to educate your own personnel. One of the things that is already in place when it comes to the AI Act is AI literacy, meaning that all the organizations that utilize AI are responsible or they need to perform to offer education to their employees in terms of the AI literacy. So make sure you have educational programs available to your employees, not because this is an obligation coming from European legislation, because it's useful for you to have people who truly understand what basic terms we mean. What is machine learning? What is an algorithm? What is a general model? How do we approach this? What is an LLM? What does it mean when I communicate with, for example, ChatGPT? What does it mean when I give my voice to 11 labs? What happens with this data? What happens with the sound of my voice? Is this secure? Is it not secure? What are the implications of us sharing every piece of information we have with big companies that are offering such tools? Whether it's the same thing if we are doing this personally and dealing with our own information, or whether we're sharing other people's information, or we are public servants and we're using state information, public information, or citizens' information, where this can lead to, and whether we are aware of the risks, and whether our organizations have systems in place that enable us to say to a certain that with a certain level of certainty we are providing secure ways of managing this information and analyzing this information through algorithms, through code that adheres to certain technical standards of quality. So these are the sort of questions. Tomek, good morning, Tomek. Your comment is, please update us on the amendment to the criminal code in Croatia versus the AI. So the point is as follows. There was recently a discussion in Croatia whether we should amend our criminal code and insert a criminal act in connection with the AI. And so now this proposal is I think still in public consultations. And I've seen some of the IT companies from Croatia being very vocal in opposition to this, because they fear that the idea behind this amendment is to criminalize AI companies, IT companies. I fear that they haven't properly understand the basics of this amendment. I think the core purpose of this is to ensure that people, organizations that use AI, and if or while utilizing an AI system, they do something that is normally considered to be a criminal act, that they can become potentially criminally liable. This also potentially includes those who are on the development side. I have developed systems that are creating things that can be normally considered as criminal acts. So in other words, if you have very particular systems in place, such as let's say, semi-automated advanced assistance, driving assistant algorithm that is helping cars to be autonomized to a certain level, or automized to a certain level, level 3, perhaps even level 4 in certain countries like China or the US, then the question is being raised, if the algorithm has created cause the damage to the extent that a horrible thing has happened, such as people losing their lives. Just maybe a few days ago, 3 people tragically lost their lives in China. From what I know, in the US, 17 people have died as a result of AI being in charge of a driving functions dynamic control over the motor vehicle in the US. One has to ask whether there is a system in place that allows a responsibility of somebody, even criminal responsibility of somebody. And when you look at the European examples, French have already amended their criminal code back in 2021 or 2022 to allow for criminal proceedings against the producers of these systems in case it can be proven that there is a fault on the side of the system that was in charge of the motor vehicle at the time of the accident. So it's not simply saying, aha, well, you have written the code, and now you can go to jail if something goes wrong. It works in the same way as if you were a physical person committing a crime, and there is the same procedure in place. So it's this amendment to the law, from the perspective that I see this, is not meant to specialize a different kind of category of criminal act that is different from everything we've seen so far. It simply allows for the state to be able to prosecute in case criminal acts are being done by means of utilizing AI systems. In the current regime, this is very difficult to achieve because we haven't had such a provision in our criminal code yet. And I think these sort of provisions will become more often and often, and they will There will appear in other laws as well. On the European level side, there was an attempt to come up with the artificial intelligence directive on non-contractual liability for AI systems. The Commission ultimately decided to put a hold on this directive. Maybe they will make it a bit larger and talk about software liability in non-contractual sense of what happens if your software creates damage to third persons and can they claim against you. So the basic point is, if you have a car, I'll give you an example in the transport law. If you have a car that has a certain level of autonomy, you go to a highway in France, Germany, or somewhere else, you press a button and the car drives on its own on the highway, and there is an accident. One has to ask if it can be proven in the court that the way that the system was developed, produced, if you like, is faulty, and because of this fault in the production, accident occurred. The new laws in place that started to come out since 2021, 2022 are saying, well, alongside the owner of the car, one can claim against the producer as well, producer of the car or producer of this AI system. And the idea, and now with the enhanced product liability directive, perhaps some of you already heard about this before, the idea is to place more burden on the producers and developers, if you like, and to explain to the public at large, that the developers, especially those who continue the digital connection or connectivity with the products, such as the example of the cars, the update of the OS, GPS system, et cetera, simply to explain to them that if they are providing certain digital services to their product after the sale, and these digital services are required for the product to perform the promised functions, then the producer, to that extent, remains liable throughout the whole life cycle of that product. And this is something that I assume many of you here are IT developers, need to be aware of. You need to be aware of this product liability directive and the upcoming non-contractual or AI directive, whenever this comes, in whatever form it comes, simply because of the way that the European market functions and because of the enhanced consumer rights that we enjoy in Europe today, there will be more burdens coming on your side in terms of technical compliance, if you will. But this is something that is expected for anyone who wishes to participate in the European market. A lot of the IT companies I work with are saying this is creating a lot of bureaucracy, a lot of burdens, a lot of financial burdens on us. And it's hard for us to keep up with the competition coming from Asia or the US because we have to pay more than the others, which may or may not be true. I'm not in the business side. I do understand that there's a lot of money to be paid, especially if you're a startup. That can be quite difficult. But at the same time, I see a lot of US companies, some of whom I've already worked with or are currently working with, who are asking me to help them with GDPR compliance and AI Act compliance, simply because they want to enter the European market, because they're very interested in participating in the European market. And they are willing to pay because they understand the benefits out of the number of targeted audience they have in Europe as well. So you can look at this as a burden, and you will be correct to this end, but also look at this as the benefit, because once you're compliant with all the mechanisms that are present in the European market, it's almost safe to say that your product is of top quality in the world on the global scale. That's this allowing you to go to any other market, and without too much of a fuss, you'll be able to compete there as well. And then this has been increasingly felt by U.S. companies who are now coming in. It's quite interesting because on the geopolitical level, there's a lot of talk about U.S. not being happy with the way that Europe regulates certain things, but in practice, more and more U.S. companies are coming here because they see all the benefits of the market participation. Are there any other comments, questions? I'm looking at the chat right now. Feel free to add your opinions. And if not, I'm passing the floor back to Agnieszka.
I do not see more questions. So thank you very much, Mihael, for your insights today. And of course, big thank you to you all for joining us. It's been a real pleasure to have all you here. Just a quick reminder, the recording of today's session will be available on LinkedIn. So we would love to stay connected with you. So please follow us on LinkedIn. And of course, if you have any questions or would like to continue the conversation, do not hesitate to reach out to us. Michael, if you will agree, we will send your details to our participants. And I think that's it. So thank you once again and
Thank
have
you.
a wonderful day and see you next time.
Bye.
Thank you. Bye bye.